base about something that is very near and dear to me, and that you're going to hear it and be hearing a great deal about in the coming weeks as we gear up for the Rockwall Veterans Business Alliance partnership with Court-Appointed Special Advocates, also known as CASA. So starting with where the Constitution of the United States of America falls on the rights of a parent to raise their children, our Supreme Court said in a paramount case, Troxel versus Granville, that the recognition of a parent's right to raise their children is perhaps one of the oldest, if not the oldest, fundamental rights that we recognize in this country. The recognition of the fundamental liberty by parents for the care, custody, and control of their children has been given paramount deference by the Supreme Court of the United States. However, that fundamental liberty is not without bounds. When the state police powers are triggered, in other words, when there's something going on in that parent's home that is against the peace and dignity of the state of, in our situation, Texas, the Supreme Court has likewise recognized that that fundamental liberty can and should be interfered with, terminated, modified, and it's a situation essentially where the state becomes the parent. And that is an unpleasant thought, but it is one that is done on a more regular basis than I was ever aware before I started getting involved in cases with CASA. Essentially, the state gets involved to protect children from abuse and neglect. Abuse, alcohol, domestic violence, drugs, neglect as a result of abuse or alcohol or drugs or domestic violence, things of that nature will trigger the state's intervention in a parental right. And what generally happens is an ex parte hearing, which means it's a hearing without the presence of the other side, that will result in a suit being filed, a child being taken away from a parent and placed in foster care, usually next of kin, if that's available, if not, someplace safe. And the reason for that is because there's an immediate danger to the health, safety, and welfare of that child, and to prevent continuing harm or continuous harm, and to get them out of a drug environment or something to that effect. It is a short deprivation period before a hearing can occur. If a party to a CPS suit, a mother or a father, cannot afford counsel, counsel will be appointed to them because it is a matter of fundamental liberty, fundamental rights. It can trigger penal interests, which means that a parent could be jailed for neglectful activity. So therefore, if they're called to testify in that court, they have to be cognizant and aware that their right to liberty is at risk, which is one of the reasons that they are appointed counsel or maybe appointed counsel in that scenario.